could be any type of communication. Where other
Well,
people are going to hear.
what you need to be careful about is when you do speak to people, you have to be careful with whom are you speaking. So if you're speaking with other people who are in that particular governing body with you, that's when all these open meetings law issues would occur. So if you're on a standing committee of the council and something's going to come up to you, you'd have to be cognizant of who you're speaking with there. If you're speaking with someone who's not an elected or appointed official on something, or you're not serving on the same body with them, then generally these open meetings law issues do not occur.
Just from my perspective, the basic rule is that if there's anything that you want to talk about related to council business, think twice before you get involved in discussions that if they became public record, it could come back and bite you. It's a tough situation, but you know, as elected officials, we get rights as individuals. It to be whether it's right or wrong, I don't know, but that's kind of the rule I go by. I was about to send an email the other day, and then I said, no, it's construed, and so I just didn't send it. And it's something that we just have to keep. It frustrates the heck out of me, but it kind of is the way it is. Anyone else?
Rich.
Stefan, you have made note a quorum is a majority. Why is it that when we hold a city council meeting or a committee of the whole, we have to have 2/3 for a quorum instead of majority?
I believe that's by state statute.
That's by state statute. And what about a standing committee?
Standing committee is a majority of the members of that committee.
Okay. And then the 4/5 rule for the redevelopment authority, is that state statute?
Yes.
Okay, thank you.
And Mr. Satori.
Thank you. I always thought that was called politics, when you can talk back and forth with people. But another thing though, how do we, let's say when we get done with the council meeting and then a few of us go to some place, you know, you just can't talk about what you did that day? It's just totally, can't do it.
Well, the purpose of the memoranda that I put in the council member handbooks are, if you're looking for bright lines that will keep you out of trouble from the Attorney General or the District Attorney, then you should follow those memoranda that have it. Otherwise, these lines can be blurred very quickly, depending on who you speak with and when you speak with them, and if it has or has not been noticed.
Because I mean, in Washington, you see all the time when the Congress or the senators getting together, they're all walking around and they're talking and trying to drum up support for things that they're trying to get passed. So if we can't do that, in other words, what we'll be doing is talking at City Hall amongst everybody, not separately with anybody.
Well, with the state and federal government, I believe they write special rules for themselves that they don't give to local municipalities as well.
And they write the rules for us too.
So in other words, we need lobbyists to do it for us? Thank
Okay.
you.
Just to follow up on Mr. Satori, isn't there some kind of state statute saying that there's such a thing as a social, and that's what I think what John is referring to. If it exists, could you elaborate on that?
Right, there's like I said, the presumption is if one half of the members meet or together, then it's presumed to be a meeting, but it excludes social meetings or meeting by chance. But as council members, what you need to be aware of is, like was mentioned before, why are you getting together, and what are you going to be you know what you're going to be talking about. So don't be doing things that you shouldn't be doing.
And then I have one last question, getting back to what Mr. Sweeney was saying. Remember we had the outgoing meeting of the old, something that the outgoing council does, can that be reconsidered in the new council?
It would have to be done by somebody who's on the prevailing side.
So in other words, something that was done with the old council, something that was, an act that was done by the old council, one of the last things they done, could be reconsidered by the new council, provided you have somebody that was there on the old council.
Provided the motion is being made by somebody who's on the prevailing side, for that whatever particular motion it was, and then the person who seconds it can be any person. It doesn't have to be somebody on the prevailing side either. So, yes, it appears that somebody would be able to do that.
I guess just to follow up to that, is that your district or is that your person that you're voting for?
I guess I don't understand.
Like we vote as districts. If somebody in my position would vote for something, now I'm the new district member, so the person voted for it, but I would want to vote against it.
It'd have to be, I'd interpret it as the person who actually voted on it. So if you're replacing somebody, then, but then again, too, that also raises that question I've talked about, the difference between the 1915 version and the 10th edition. If, they say if somebody wasn't part of it, they'd be able to make a motion as well. So it's one of those great answers as a lawyer. I get to say it depends. And so it comes out. You know, I live in the, you know.
Okay. All right. And then I would probably wrap up after this answer to this question.
Just a quick one, Stefan. Why do we use the 1950 version instead of the modern text?
I don't know. I don't have that answer. The only answer I have is that's what's written in our rules.
So it's time to look at our rules.
Well, I don't know. The 1915 version, I think, is 200 pages. If you want to go to the 10th edition, I think you're going to add, I don't know, 400 more pages. And I don't know. We don't have to use Robert's rules. There's other authorities for parliamentary procedure as well. And I think, indeed, Robert's rules also writes special parliamentary procedure manuals for, I think, governmental entities. Like, for example, the 10th edition, I think, is written for, the real focus of the 10th edition is for bodies that have hundreds of members. So then there's a separate rules that are set for people that have smaller membership. And then there's special rules for membership where you only have like 5 members. And there's all different types of things out there that we could look at.
How many pages is
Yeah.
Well, perhaps that's a project that we might want some people to review the various editions of Robert's Rules and see. Personally, I'm all for the one that's shortest because it's the quickest and easiest to reference, and basically Robert's Rules are helpful. The biggest problem with Robert's Rules is the lack of knowledge of people and the lack of will of people to follow Robert's Rules. But anyway, that's a whole other debate. Thank you, Stefan.